Okay. Hi, everyone. Thank you for joining us for our presentation regarding national interest visa waivers. In particular, just wanted to talk a little bit about our firm. If you're not familiar with our office, we practice business immigration. We've been doing this for 17 years myself. Jenny's been doing it for 7 years. We've been practicing immigration mostly in the business sector. We have some family-based cases as well. We have an office in Silicon Valley in Fremont. We have an office in Thailand, Japan, and also in New York, which is our headquarters. We really believe that the client or the foreign national deserves and requires really a good attention to their immigration matters because it's so important. So we really value actually doing a really good job for them, and we want to make sure that when we talk about immigration matters that we focus on the needs of the particular individual that we're dealing with. And today we're going to talk about the national interest visa waiver category. It's a little bit of a complex category, and we want to focus on 3 main areas for the national interest visa waiver. First is, what is it? What is a national interest visa waiver? Second is, who qualifies for it? And third, what are the pros and cons? These topics are really relevant for the purpose of determining whether or not this is a category that you qualify for, and that it's important to understand what the requirements are. In order to do so, I think we need to go over the basics. So let's talk a little bit about employment-based visas. So Jenny, what do you think? When you actually apply for a green card, what are the general avenues that you can use to get permanent residence in the US?
So I'm going to give you a brief overview of the employment-based immigrant visa categories. Most immigrants to the US obtain a green card either through family or through work. And immigrant visas issued for those who want to live and work permanently in the US. On this slide, you're going to see 3 of the most common employment-based visa categories: EB1, EB2, and EB3. EB stands for employment-based, and the number 1 stands for first preference category, 2 is for second preference category, and 3 is for third preference category. So the EB1 visa category is for priority workers, and there are 3 types of EB1 petitions. The first type of petition is for individuals with extraordinary ability in the sciences, arts, business, education, or athletics, and they have to show sustained national or international acclaim in their achievements. The second type of EB1 petition is for outstanding professors and researchers. They have to show international recognition of their achievements in a particular academic field and at least 3 years of teaching or research experience in that academic field. The third type of EB1 petition is for multinational managers or executives. You have to work at least 1 year or the last 3 years overseas with a company in a managerial or executive capacity, and you're coming to the US to work for that same company in a managerial or executive capacity. So the 2 companies need to have a qualifying relationship, such as a parent and subsidiary or 2 affiliates of the same company. So to qualify, moving on to the EB2 category, to qualify under EB2, you have to be an advanced degree professional or an alien of exceptional ability. An advanced degree professional is someone who has a US master's degree or higher, like a PhD, or the foreign degree equivalent. You can also qualify as an advanced degree professional if you have a bachelor's degree or the foreign degree equivalent and 5 years of progressively responsible work experience. What progressively responsible means is that you have advanced in your career. For example, you started out as a junior software engineer and you became a senior software engineer, and now you're a software engineering manager. The other way to qualify under EB2 is as an alien of exceptional ability in the sciences, arts, or business. Exceptional ability means that you have a level of expertise that is significantly above that which is encountered in your field. The third category, EB3, third preference category, is for professionals, skilled workers, and unskilled workers. Professionals have at least a bachelor's degree or the foreign degree equivalent, and skilled workers have to show at least 2 years of experience or training. And unskilled workers can show less than 2 years of experience or training, but the unskilled labor must not be temporary or seasonal in nature.
So this is really helpful to know just like some background information about employment-based cases. So let's talk a little bit, you mentioned about the labor certification. So why don't you talk about that a little bit?
Yeah, so I'm going to talk about how the labor certification fits into the employment-based green card process. As some of you may know, labor certification is generally the first step of the employment-based green card process. And some of you know that this is a stage where the U.S. employer has to test the U.S. labor market to make sure that there are no minimally qualified U.S. workers available for the position being offered to the foreign national. And labor certification can be very onerous and time-consuming and expensive. It can be very time-consuming because it takes months to get a prevailing wage determination from the Department of Labor and also to conduct recruitment before a case is filed. And once the case is filed, it can take about 3 or 4 months right now for the case to be processed by the Department of Labor. But if the case is audited, then it can take a year before a decision is reached. And it's also expensive because the employer is required to run Sunday ads in newspapers, and depending on the area of intended employment, the ads can run a few $1,000s. And finally, if a qualified U.S. worker is found, then labor certification cannot proceed. You cannot file the case. And you can see on the slide, for EB1 petitions, labor certification is not required. But in general, for EB2 and EB3 petitions, labor certification is required.
So that's really important to know. And we're going to talk a little bit now about what the benefit of waiving the labor certificate requirement is. So let's talk a little bit about the EB2 category, since this is an option as well. To waive the national interest visa waiver is an option so that you can actually waive the labor certification requirements. You want to just touch upon that?
The national interest waiver petition falls under the second preference, employment-based second preference category. You still have to meet the minimum requirement of being an advanced degree professional or an alien of exceptional ability, and you also have to meet the national interest waiver requirement. With this type of petition, you're asking the government to waive the requirements of a labor certification and a job offer for the sake of the national interest of the United States.
Let's talk a little bit about the national interest itself. So with regard to what is a national interest waiver, why is the U.S. government interested in allowing someone who gains permanent residence or given this benefit if they have basically what we consider skills or abilities that benefit the U.S.? So above here is the regulation itself. Immigrant visas are available to qualified immigrants who are members of professions holding advanced degrees, like Jenny said, or individuals of exceptional ability in the sciences, the arts, business, and they will substantially benefit prospectively the national economy, culture, or educational interests or welfare of the United States. So there are 3 main components for the national interest waiver. One is that they have what they call substantial merit and national importance. Those terms are very important in looking at someone's contributions. The foreign national also has to be well positioned to advance the proposed endeavor. Now, advancing the proposed endeavor also means that they actually have the skills or the education or the ability to do that job that's going to allow them to further benefit the United States based on what they're doing. Lastly, on balance, it would be beneficial to the U.S. to waive the requirement of a job offer and a labor certification. We're going to break those down and talk a little bit about each of them. But before we do that, we want to talk a little bit about the intent and purpose. Going back to what Jenny had just talked about, the permanent residence process is meant to protect the U.S. labor workforce. It always looks to whether or not the U.S. workforce is being protected for that particular role. The intent of the national interest waiver is to waive the labor certification requirements because of the U.S. national interests. So the goal is very different than what the U.S. regular labor certification process is about. And the purpose is really to allow the U.S. to benefit from the best and brightest in the field. Now, to demonstrate that is really the requirement. How do you demonstrate that you're contributing a skill or a need to the U.S. that's basically beyond the scope of what is regularly available in the U.S. workforce and that would benefit the U.S. substantially? We're going to talk a little bit now about the evolution of this category, because I would say in 1998 there was a case that was decided called New York Department of Transportation. New York State Department of Transportation that limited the interpretation of national interest waiver and kind of put a stop to moving forward with green card cases in this area. Before, the New York State Department of Transportation case required that the work must be in an area of substantial intrinsic merit. In 2016, December 27th, there was a new case called Matter of Danossar that was decided, and that became what they call the precedent case. That case is now the one that they're actually using as a framework to determine whether someone qualifies for the category. So now the new framework is that your work has to have both substantial merit and national importance. Now, even though those terms can still be, I would say, they can still be interpreted, the idea is that instead of focusing on intrinsic merit, which is something that's inherent in what you're doing, they're looking at the benefit of what you're doing to the US. Why are you doing this, and how is it going to benefit the United States, and why does it have merit in the particular area that you're working on? That's pretty open-ended. The second change, you want to go ahead and talk about that?
Yes. So under the old New York State Department of Transportation case, the second prong states that the benefit of your work must be national in scope. And this is being construed very narrowly by focusing on the geographic impact of the benefit. So if the benefit was limited, say, to one area or one state, it wasn't considered national in scope. Under the new Danosar test, the second prong now states that you have to be well positioned to advance the proposed endeavor. So what are some of the factors that are considered? The government will look to see if you have the advanced degrees, whether you have the research experience, whether there are US government agencies that are interested in your work, whether you have investment funding, or whether there's been commercial utilization of your work.
That's very helpful. And then one of the biggest changes is really looking at again, a big picture change, because in the past, the New York State Department of Transportation case required that you serve the national interest to a substantially greater degree than would a comparable US worker. And then the second thing they wanted to show is that the national interest would be adversely affected if the labor certification were required. Now, it's more of a positive change where the government's looking for, on balance, that it would be beneficial to the United States to waive that labor certification requirement and job offer. Instead of looking at the negative, showing how how the U.S. would be harmed by actually not having this, or not having a labor certification proceed, or having a labor certification waived. They're looking at the positive. What are you bringing to the table? What is that particular skill that you're adding value to actually the U.S. if you are waiving the job requirement and the labor certification? So that's something that is really important, because that third change had changed actually the whole framework of what they're looking for. Another thing we want to talk about is now who qualifies for it, because even though the area is really broad, there is some specifics that the person needs to meet before they qualify for a national interest waiver. So let's talk a little bit about that. Notice that there's really no specific field of study that you have to demonstrate that you're a member of the professions and have an advanced degree, or you're an individual of exceptional ability. So you don't have to actually have a degree in physics or a degree in specific area, but if you're going to make that argument that you qualify for the national interest waiver, you have to demonstrate that you have an exceptional ability or the advanced degree. Some of the things that we want to emphasize here is that when you're presenting the matter to the US government, you always want to frame your argument. You always want to think about, how am I presenting that information to the government? How am I showing that I actually qualify for the category? So one of the things you want to do is to talk about your contributions.
So you should look at all of your accomplishments to date and demonstrate how your contributions stand out. So you should think about what contributions have you made to the field that are greater than others who have the same degree of experience, education, and expertise. For example, you've developed a method to profile gene activities at the single cell level, and your method is being used by other scientists to conduct research. Or you developed a radar device that can be used in defense programs.
That's a really good point. And then also, think about ways that your contributions are what they call disruptive. If you think about what novel areas that you've worked on, maybe things that have advanced the field, maybe you're doing something that is building upon some technology or some development that has already been in place, but because of your research, you've actually made leaps and bounds. Maybe it's faster in analyzing data or in any particular area of scientific research. That does help if you frame the argument that what you're doing is novel. And then further, that your contributions are important. So you can't, I think the best way to explain this is if you're developing, say, an app or developing a technology that you think is going to maybe monetize something, it doesn't necessarily mean that it has relevance to the US. How is it relevant and how does it impact the US or the industry? If you're developing a technique to, maybe your app is going to educate autistic children in a way that's going to develop a brain change in them, or something that very specific to benefit the US, benefit US national interests, maybe even national interests overall or worldwide importance. This is the kind of thing you want to think about when you're framing your argument. So let's talk a little bit about ways that you can increase your chances of qualifying for this category. So one of the things we always say is try to focus on the innovative and original contributions, just like when we were talking about what Jenny was mentioning about, anything that's new, anything that's not necessarily done in the past. And again, it's pretty open-ended in terms of the fields. Another way is
The second tip is to obtain independent advisory opinions from people who know of your presentations and publications or your accomplishments in the field. So one way to do this is to obtain letters of recommendation from people you have not worked with, because objective letters carry more weight with U.S. citizenship and immigration services.
Yeah, it's always helpful to get someone outside to comment on it. Also, as I mentioned, explain how it affects national economic, cultural, or educational interests for the welfare of the U.S. both positively and substantially. Again, you can't focus only on the research that you're doing. You have to think in terms of the broader range, why is it that what you're doing is valuable to the United States and why is it important? And then lastly, you want to think about ways that it serves the national interest to a substantially greater degree than someone else who's qualified and then making a greater contribution than other skilled researchers. Now, there are a lot of smart people. There are a lot of people out there that are doing research maybe in your area. Well, how are you going to distinguish yourself from individuals that are doing the same thing that you are? So you want to always think ahead where if you're working on something, apply it to the bigger picture, apply it to the larger view of why you're doing it. The narrative that you're presenting to the U.S. government should encompass areas that are not just focused on your particular technology, but the bigger picture. How is that technology being applied? How is that particular research going to grow this particular area of research that's going to change something that's significant to the U.S.? So let's segue a little bit and talk a little bit about the pros and cons, since that's really important to figure out as well. I think we should always focus on the pros. so let's talk about pros.
Okay, so here are some of the advantages of pursuing a national interest waiver petition. The first is that it's a path to U.S. permanent legal residency status by self-petition or through an employer. So as we've mentioned, you don't need a job offer to file this petition. You can file it yourself. And the second advantage is that you can bypass the labor certification process, which I mentioned is very time-consuming and expensive. And the third advantage is that you can simultaneously file the Form 485 adjustment application if your priority date is current. Now, what is a priority date? So every year, the immigrant visa that are issued every year is very limited. So your priority date is like your ticket in line for an immigrant visa. And for employment-based visas, the priority date is the date that your labor certification is filed with the Department of Labor, if labor certification is required. Or if labor certification is not required, it's a date that your immigrant visa petition is filed with the U.S. Citizenship and Immigration Services.
Why is that important?
So if your priority date is current, you can simultaneously file the adjustment application along with the national interest waiver petition.
This ties into why this is a problem for some individuals, because if you look at the cons, aside from the first one, which is that there is some degree of subjective review. Actually, that's really one of the most important ones, because when you frame your argument, you present your argument to the U.S. government, there is room for interpretation. As much as you want to say that what you're doing has substantial merit and national importance, there are precedent cases that may allow the government to render a decision that may not be positive for your case. You always want to build the strongest case you can, but because it's not math, there is times when the government can come back and believe and argue that what you're doing does not meet their standard of what substantial merit can be. Of course, there's ways that you can build it, but you always want to make sure that you take a look at the reality and try to measure what your accomplishments are in the bigger picture. And if you can argue that's novel, there may be a more room for you to indicate that you're doing something that's more unique and hopefully gain an edge that way. But the more challenging aspect of the EB2 category is for individuals that are born in certain countries, such as India or China. As Jenny mentioned with the visa bulletin, the U.S. government allots 7% of employment-based visas to individuals from each country where they're born. So they're looking at the country of birth. And in particular, for individuals born in India or China, the EB2 category is quite backlogged right now. What that practically means is that even if you qualify for this category, it may be very difficult for you to advance to the next level to gain permanent residence. However, if as Jenny mentioned, if you file the case concurrently, you may be able to get employment authorization outside of another basis to do so, such as an H-1B or O-1 or another visa category. So that could be a benefit, but everything is hinging upon the I-140, the immigrant visa petition under the national interest waiver category. So if that doesn't go well, then your basis for employment will no longer be valid. And then lastly, it can't be filed with premium processing. Premium processing is a fee that you pay to the US government to allow the government to process the case faster, and usually in 15 days, barring a request for evidence. However, with the national interest waiver category, there is no premium processing. So sometimes you may see cases that take a year to get approved. You may see cases that are approved in 4 months. It just varies a lot. So it's a little bit of a risk. We wanted to show you the priority dates in the visa bulletin. I think that, we talked a little bit about that, and the slide is a little, it's only a representative slide with regard to some of the countries, but as you can tell, maybe Jenny, you can talk a little bit about the timing. Yeah.
So every month the State Department publishes this visa bulletin, and this is the visa bulletin for August 2017. And you can see that the national interest waiver petition falls under the employment-based second preference category. It's highlighted in yellow, and you see all these dates there. These dates are called cutoff dates, and your priority date needs to be earlier than this cutoff date in order for you to be able to file your adjustment of status application.
Yeah, so as an example, if you look at India, it's July 22nd, 2008, and what that practically means is for EB2, the national interest waiver petition had to be filed prior to that date in order for them to even get a chance to gain permanent residence now. So it's not really as conducive or a good category for certain individuals. However, as we talked about earlier, it does put you in the running for gaining permanent residence. Let's just say the I-140 got approved, you filed the adjustment concurrently. You can extend your employment authorization and travel document pretty much ongoing until the time where there is a priority date available. Now, right now it's almost 9 years for Indian-born nationals, and for China-born it's like 2013. So, I mean, I think that just thinking about it, it could still give you a benefit, it's just not an immediate benefit. So we're gonna segue a little bit into some sample scenarios because it's probably a good way just to kind of get an idea of what, maybe what kind of person would qualify, and maybe some questions that could come up that are typical. And let's take a look at this scenario. So I'm currently a PhD student. I'm doing novel research in big data and machine learning. I think that what I will do will benefit the US, but I haven't yet graduated. Do I qualify for a national interest waiver?
So it depends. If you already have a master's degree, then you would meet the minimum requirement under the EB2 category as an advanced degree professional. But the second part of the analysis is whether or not you meet the national interest waiver requirements. So you would have to demonstrate under the new Danaher three-pronged test. You have to show whether or not your work meets the substantial merit and national importance, whether you are well positioned to advance the proposed endeavor, and whether on balance it would benefit the United States to waive the requirements of a job offer and a labor certification.
Yeah, that's a good point. And there's no guarantee of that, right? Yeah. So there is some argument to be made here. I think that, another scenario that we think is probably a pretty potential one for some people is this one.
So this scenario, I am an artist and a designer. My work has been featured in numerous publications and marketing campaigns, but I didn't graduate from school and I don't have a degree. Do I qualify for a national interest waiver?
And this, again, it also depends, because in this case, the person doesn't actually have a degree. However, they may qualify under what they call the exceptional ability requirement, which would require that they have a level of expertise that is beyond what is common in the particular field, and that what they're doing would actually substantially benefit the United States. In particular, that they're well positioned and qualified to actually have the necessary benefit for naturally skills in arts. In particular, this person would be in art area to actually show that what they're going to do is going to impact the U.S. in a substantially greater manner than someone else. And once they prove that, so it has elements of actually the national interest waiver requirement, they still have to prove at least 3 of the following. They have to show that they have 10 years of progressive full-time experience. Maybe not progressive, but just full-time experience. They just need to show that they have something other than their art. And then on top of that, they need to show that they're members of particular groups, like associations. They also have to show that maybe they gain remuneration in a particular area, like if they got a grant from MacArthur or they had some sort of government grant that they've gained based on their work. They also have to have recognition from their peers. So you have to show some of these areas that, recognition from peers, such as people that are in the field that can attest to their art or what they've been doing, their design work. Maybe they've garnered some press or media. They've done a portfolio and they've been exposed to, their work has been featured in magazines, or something to show that they are not just doing what is typically someone who's been in the field for some time, that they have to demonstrate some degree of advancement. So take a look at the third scenario. So I'm an MBA student and I don't have much in the way of publications or research. I plan on starting my own company and seeking venture funding after I graduate. Do I qualify for a national interest waiver?
So if you graduate with your MBA, then you meet the minimum requirement for the EB2 category as an advanced degree professional. Mm-hmm. However, the issue is whether or not starting your company at this early stage would meet the national interest waiver requirements. And since there's no track record to show how your work meets that substantial merit requirements, it may be difficult for you to meet the threshold requirements for the national interest waiver.
Yeah, and then what could help is if you have venture funding, Series A, if someone actually gave you money to do a particular type of research, or your company, I mean, sometimes you can make that argument that you've already received a degree, you are in a well position to further the endeavor, and that on balance, what you're going to do is going to impact the field, impact the U.S. in a substantially greater degree. And look, all these people that would only invest in companies that have had track record of success have invested in my company. So sometimes you can try to make that argument. The question is whether or not it would be sufficient. And I think that if you were in this scenario, you probably want to think about Plan B and have more than one option available, because if this fails, then you may not get the option to move forward with permanent residence, or at least get continued employment authorization. So does anyone have any questions? Yeah.
Yeah, I have a question about this national importance thing. So, could you flesh out a little bit more about what is nationally important to the United States? Like, for example, if I had I do have a breastfeeding app on the App Store, right? It has several thousand users, paying users, and in a sense, I'm helping all of these women in the country, across the country, in the United States. So I guess I'm just wondering, would that potentially be helpful for the United States? Would that be nationally important enough? And I do have a grad school degree and so on, and I'm not from China or India.
Sure. I think that this potentially could have national importance if you draw it as sort of a process that would allow someone to gain actually can't go back to work, or feel like there's barriers to returning to work because of raising children or other benefits that they are gaining. So one of the things we always want to do is think about how it would benefit. I mean, as much as it's a very important part of the technology, maybe this app is going to help and it's going to do all these things. We want to draw the bigger picture. How is it going to help? What is the demographics for women going back to work? How many people have using this for purposes of determining if they qualify for a job or if they had a career, and draw the bigger picture. I think that it's always a little bit of a challenge when it's not tested in the way. I mean, but you always want to think about it that way. So, I don't know, Jenny, if you have anything to add to that.
One follow-up.
Yeah.
Who are the people who are looking at if I apply for the national interest waiver, who's looking at, who's deciding if it's nationally important or not? Is it a group of people? It's just one person? And if it's one person or multiple people, do I get lucky sometimes or not? Because sometimes for areas like this one where it's slightly more unique, there's more room, as you said, room for interpretation, I guess.
Yeah. The USCIS is, the officers that do decide these cases have generally been trained. So they have a lot of experience in looking at a broad range. Now they have this new framework, which was established in 2016, and they're being trained, and they have been trained on it. So those are the target audience is the USCIS. And the best way, I think, to look at it is to understand just all the precedent cases that have been decided in this area, in particular the sciences. If you see or apps or anything new, you want to make sure that there's visuals, because the officers are not experts in your area. They need to be educated. So as you start thinking about how do I qualify for this category, you want to start drawing attention to statistics, national data to show like why is this important, kind of build the argument. You have to present your argument to the government. So the US government is the one that's rendering the decision, the officers. And most of the time they're looking at not only your area of qualification, but sort of like the bigger picture. Because there are other visa categories, I think that, maybe Jenny, you can talk a little bit about that you may also qualify for.
Yeah, so the National Interest Waiver Petition, it's a good option for like scholars, researchers, postdocs, and PhD students, and those who are sort of in the earlier stages of their career. And it doesn't preclude you from applying under different employment-based petitions. If you do qualify under the EB-1 visa category as an with extraordinary ability, you can still file a petition under EB-1 as well.
Yeah. Yeah, so I think I always try to look and take a look at what the government has decided in that area before, like medical doctors. I mean, those are a very specific group of people, but you always want to think about the broader picture. What have people have said before? What is the deciding factors that made this case get approved in this area, if I can find that? Like an artist, I mean, it's so, one of the things about certain things you can measure, and there's certain areas of study or areas of endeavor that is really more subjective, like art, for example. So you kind of gauge what area you're in, and then try to make your argument that way. Yeah.
Do you recommend MBA students to apply for NIW if they are qualified before graduation or after graduation?
Yeah.
And how this application will affect their OPT application?
Yeah.
And if they arrive at the end of their OPT and if their NIW has not approved yet, so what will happen beyond their OPT if they have still a pending NIW application?
Yeah. That's a really good question, because one of the things that the National Interest Waiver does, if they're not barred from proceeding due to the priority date, is that they can actually gain work authorization. You can file concurrently, like Jenny had mentioned earlier. So if they have a strong case and they file after or before their OPT EAD expires, it would be likely that they'll be granted another OPT EAD. Well, it's not OPT EAD. They will be granted employment authorization based on the adjustment filing, which would enable them to work. The risk is that if their case isn't that strong, they may face a year later a denial and then lose their work authorization. But once you switch over to the green card case, you are no longer a student. So you may want to think about the timing of when that happens. So this is a really good question, because the timing is important. If they've already had OPT, maybe they want to exhaust it, maybe towards the end of 3 months before, file for the EAD, AP based on the NIW, and then be able to continue working and renew it. Now, if the government takes a year, you're getting a year, right? So, and in the meantime, someone can sponsor you for an H-1B. If as Jenny mentioned, if you qualify for a different category, you can try for that. So you want to open up that option. But first, you want to analyze, as you start thinking about the National Interest Waiver, is this something I can do? Another benefit is you can self-petition. So one of the things is, instead of having Google or some big company sponsor you, you have the ability to build your own case. It takes effort. It takes a lot more effort and time, and you got to think about what you've been doing. But if you're able to build that strong case, you have that independence that you don't necessarily have by being tied to a company or an organization that's sponsoring you. Yeah.
And they have two pending applications at the same time, ED1 and ED2.
Yeah.
Employer will apply for ED1 and they will apply themselves for NIW. So they will have at the same time two applications for ED1 and ED2 cases.
Yes, you can have it pending simultaneously.
Yeah, and then the issue is then when you get towards the deciding day, so say you have EB1, EB2, and both of them get approved. Then at some point, the Foreign National will have to decide which one do I want to go forward with. Now, at the EB1, you can also self-petition. So if they have a strong EB1 case that gets approved, priority date's current, they're Chinese, or they're Indian, maybe EB1 is the best way to go if the priority date's earlier. So if you have more than one avenue of getting permanent residence, you have a choice. So it's a good thing, if they're at that level. Mm-hmm. Yeah.
Thank you.
So in this case, EB5 was too, right? Because the MBA student actually studying your own business, and
Yes.
And that would qualify them to be an E5 category.
Yeah.
E5 takes after like 2 years. So how's that work? The student here on visa?
It depends on your country. So we didn't put EB5 on the visa bulletin, mainly because there's a huge backlog for EB5s, and there's some risks involved because every September, Congress has to renew it right now, and there's discussion about raising the threshold investment amount to 1.5 million if you're not investing in a regional center. So one of the things with EB5s is, number one, there's a little bit more risk in the sense that you don't know exactly what's going to happen with that regional center if you're investing in a regional center. And then the priority date movement sometimes is very slow, which means that between now and the time you get your green card, what if that investment fails? And then you have this EB5, you're no longer a student, and you've already expressed interest in gaining permanent residence. So you may have contradicted the ability to go back to being a student, if you've already kind of pursued this route. So, but you're right. I mean, it is a potential option if you have EB5, and then you can also apply for adjustment. You can also wait, but we've been seeing that there's been a backlog in terms of certain countries, like China, for example. There's a large backlog right now. But the government is working hard to kind of move that forward. So they're hoping to move it forward and renew the EB5 category to allow more adjudication to happen, but it's quite slow. Yeah.
When the spouse and partner of EB1 and EB2 will be qualified to vote as well?
Yes, yeah, so absolutely, yes.
Can
So,
you explain a little bit about their dependence?
yeah, that's actually, we didn't talk about dependence because we kind of focused on the principal, but that's a really, really good point because a lot of times spouses come here and they're very qualified and capable, but because of the limitations in, dependent visas, they can't work. So if your spouse is applying as a derivative applicant under the national interest waiver, they will also get work authorization. I think that's a helpful point as well. And that would be applied for both EB1, EB2. Anything that you can self-petition, they have a basis to gain work authorization as well. But again, everything is dependent on this particular area. So the best way is to analyze it first to see if you can build the case. And if you think that you can, maybe try it and then see if that's an option for you. But timing-wise is really important as well.
Thank you.
Yeah, you're welcome.
When you submit your application for national interest waiver, because a lot can happen within a year. Like for example, with a startup, you might actually get Series A funding. You go to Series B, you might get a lot. You might get like a really just like a really hot venture fund financing you. Can you send the government updates, or do they ask for updates, or once it's your turn in line to look at it since there's no premium processing?
Yeah, that's a really good question. A lot of times what happens is the government will ask for updates unless they approve your case. Now, let's just say you had Series A, they approved the case, then the company goes down. What happens, right? So you have, okay, so that's a good question. So let's just say you got the I-140 approval based on the national interest waiver, and then all of a sudden something happens, the company's going down. Now, then it depends on where you're at in the process. So let's just say, use that as an example. If you have an I-140 immigrant visa petition approved, 180 days have passed since you file your adjustment of status, you can actually port or actually have a new employer in the same or similar occupation and continue your green card. So if you are an entrepreneur, you already started the startup, you're doing something similar, the company gets bought by Facebook or something, or it goes under, and then you have another opportunity to do another startup, you can actually continue your green card, but all those factors must be in place. So in a way, it could be an option for you if that happens. So that's a good thing to think about as well, because you're right, things change, and sometimes, again, businesses, you can never predict. And sometimes if you have a great idea, and then you sell that idea away and your company no longer exists, filing concurrently may actually be a good thing. Because if you get the I-140 approved and then you have the 180 days since the adjustment filing, you can actually port to self-employment.
So there's no penalty with filing concurrently, just extra fees to the government to look at it, basically? Or?
There is no penalty, no.
Okay.
But you have to do a medical exam. So the medical exam costs money, and there's time and money involved, and you can lose all that if it doesn't go through. Yeah. Do you have any more questions? Or yeah? Okay. No, thank you for joining us today. We're really happy to have shared this with you. If you have any questions, you can certainly contact us. Our contact information is on our website. Thank you very much. Thank you. Okay. Yeah. Thanks for coming. Yeah. We're good? No, we're good.